आप आगे आ जाइए।
Madam, I am extremely grateful to you for giving me this opportunity to table the Companies Amendment Bill 2000 before this Honourable House. At the very outset, I must state that on Monday, this bill was passed by the Lok Sabha, and about 40 amendments which had been suggested by the Standing Committee had been incorporated in this bill. I am extremely grateful to the members and particularly the Chairman of the Standing Committee who very expeditiously and very thoroughly examined this bill and suggested several changes to it which was unanimously accepted by the other House. In 1996, the Government of India had constituted a committee to go into the question of suggesting a comprehensive company law bill. Suggestions were made and a report was received in August 1997, which was referred to the Standing Committee on Finance. Because the comprehensive bill went into several hundred clauses, last year in 1999, the first part of the bill was incorporated by way of an ordinance initially and then approved by both houses of Parliament. The 1999 bill, which has now become an act, had several major provisions, inter alia which referred to a provision for sweat equity for employees, a provision for buyback of shares, simplification of nomination facilities for legal heirs and representatives of deceased shareholders, enforcement of uniform accounting standards, and most important, the creation of an investor education fund. That is to suggest that unclaimed dividend lying with various companies, as also interest which was unclaimed on various deposits in companies, would go into the creation of an investor education fund. Similarly, sir, the 2000 bill has several important provisions, but the three most important provisions relate to transparency in corporate governance, improving the standards of corporate governance, and also creating provisions for investor protection. I'll just briefly outline some of the major amendments which have been suggested in this amendment bill. The definition clause has several important additions, the two most important being the new definition of the phrase dividend, as also the new concept of employee stock option which is being defined in the company's bill. Dividend, sir, now means and includes interim dividend. A large number of companies are also declaring interim dividend in addition to the regular dividend that they declare, and a legislative sanction to that has been provided for. Employee stock option, that is the giving of stocks to employees or directors of the company or officers of the company, has been specifically provided for in the bill. There is a specific amendment relating to a minimum share capital being provided for both private and public limited companies. This amendment has a dual purpose. The first being that minimum 1 lakh rupees will be the capital for a private limited company and 5 lakhs for a public limited company. So people who registered companies without any investment, and such companies may become fly-by-night operators, is to be discouraged. And secondly, even on the registrar of companies today, a very large number of defunct companies which are doing no business are just registered. Therefore, a disincentive has been created so as those companies could be taken off the register which are defunct companies and which are not doing any business. Similarly, sir, a very important amendment relates to certain deletion of certain obsolete clauses. Managing agents, treasurers, these were abolished long ago, but provisions relating to them continue to occupy the statutory space, and therefore an amendment has been suggested deleting various provisions which deal with managing agents and treasurers. Earlier, sir, the transfer of a register office of a company from one state to another required the prior approval of a regional director. Now, since a large number of vanishing companies have also come into existence, it has been noticed that they even transfer their registered offices within the state itself. The size of some of the states is very large. This also requires a prior approval of the regional director in case there is a shift of regional office within the state from one place to another. Provisions relating to some companies being deemed public companies, the private companies being deemed public companies, over a passage of time has been considered unnecessary, and it has been suggested which has been accepted by the standing committee, that these provisions also may be deleted. So a very important amendment relates to certain provisions which are related to the various market activities of companies. These functions are now proposed to be transferred to the SEBI. Several penalties in terms of fines have been enhanced almost 10 times for the defaults which some of the companies may commit. Clause 19, sir, seeks to add section 58AA. This is a very important provision relating to protection of interest of small investors. The Companies Act now recognizes the institution of a small depositor, and these depositors, once a company fails to repay back their amounts, it is obligatory for the company to inform the Company Law Board within 60 days. And once it informs the Company Law Board within 60 days, the Company Law Board is expected to pass orders within 30 days, which is extendable maximum by a period of 30 days. So a complete remedy for the small depositor from the Company Law Board shall be there within a period of 90 days, which can be stretched maximum to 120 days. If these orders are violated, there are several deterrents on a company that if you are not paying small depositors, then you cannot collect further deposits. If you collect further advances from banks or financial institutions, you have first to repay back the small depositors, and there is also a penalty which has been provided for in the amendment. Sir, additionally, there are other amendments relating to ensuring corporate democracy. Clause 80 amends section 192. Earlier, the voting at an AGM of a company was only either in person or by proxy. Now the Act creates an enabling provision that the central government may notify a category of resolutions which can be voted upon also by a postal ballot. And the definition of postal ballot has been extended by the standing committee so as also to include electronic voting. Similarly, sir, the payment of interim dividend has been made by the standing committee on its suggestion mandatory within a period of 5 days of its declaration. There is also a default clause in case knowingly dividend is not paid, then certain consequences come upon the directors of the company who are involved in the process of non-payment. Clause 101 provides for a director's responsibility statement. That is to say, directors of all categories are now expected to file annually a director's responsibility statement that the accounts of the company have been personally gone through by them. They cannot say that we have signed the accounts without applying our mind. They are personally to ensure that the accounting standards have been maintained in the approval of the accounts of the company. Similarly, sir, special responsibilities have also been cast upon the auditors of a company. If there are certain adverse comments made, and those adverse comments go to the annual general meeting of the company, they would be in bold print or in italics, so that they are not concealed behind some fine print. The shareholders know at least what is the adverse comment that the auditors have made in relation to the company. Similarly, sir, a provision has been made with regard to certain directors who default in relation to one company, their responsibilities qua other companies on which they continue to be directors. The audit committee, in order to ensure that that the financial affairs of the company are maintained at the highest level, has been given wide powers. Even though the audit committee is constituted by the board of directors, its findings have been made binding on the board of the company. In case the board disagrees, the findings would go to the annual general meeting of the company. These are several amongst various other amendments, sir, which I am not elaborating, which in this very comprehensive provision have been suggested, first by the bill when it was tabled in the House, and thereafter several additions have been made by the standing committee. I may add, sir, that the first installment, if I may use that phrase, of the 1997 draft bill has already been legislated by this House last year. The second is several amendments relating to investor protection, adding transparency and maintaining the higher standards of corporate governance, which are internationally accepted standards today, have been introduced by virtue of this bill. There is one last limb which remains, which we have not brought up along with these amendments, which relates really to an issue as to the forum on which commercial corporate disputes are to be settled. There have been several suggestions which have been made by the standing committee. The report is already with us. But there was also a parallel report relating to functioning of certain other institutions, such as the BIFR and the settlement of corporate disputes on forums such as Company Law Board. A committee headed by Justice Iradi has also made some suggestions. Now, taking a comprehensive view, the government will on a subsequent date with regard to the remaining suggestions, which relates really to the Company Law Tribunal or the Company Law Board, take a comprehensive view and then shall be bringing a bill, if necessary, within a reasonable future date, as far as the third aspect is concerned. These, sir, have been very well-meaning amendments intended to pursue good corporate governance. And I would appeal to the honourable members of the House that having been approved also by the standing committee, I commend this bill for acceptance of the honourable House.
चर्चा शुरू करने से पहले मेरी सदन से प्रार्थना है कि क्योंकि अभी 5 बजे सदन का समय समाप्त होता है, तो यदि सदन उचित समझे, महत्वपूर्ण बिल है, समिति ने देखा है, दूसरे सदन ने भी देखा है, तो अगर ज़्यादा समय बैठना पड़े तब भी हम बैठ सकते हैं, लेकिन अगर इसको आज ही हम पारित कर दें तो सदन की बड़ी कृपा हो।
Pardon? Sir, since this question has been raised by several members, I think it may not merit much of a debate if the explanation is seen. The explanation says that this provision will apply only in those cases where in a state there is more than one registrar of companies.
And can pass the information.
If you are moving out of the jurisdiction of one to another, it is only then that this will apply. And the rationale for this is a large number of vanishing companies not only shift their offices from the jurisdiction of outside the jurisdiction of the registrar of companies where they are situated, and hence we lose any control over them or any knowledge of their existence also. Earlier the provision was you can go out of one state to another state, you require permission. But today in a large state where there are 2 or 3 registrar of companies offices, you shift out of the jurisdiction of one, go under the other. This gentleman doesn't know where the company has gone, and this was seen in the case of
Maharashtra. This is made in Maharashtra.
There are today Chennai and Coimbatore. These are 2 registrars of companies. So explanation says only to those states where there are more than one registrar of companies, and you shift out of the office of one to the other so that nobody vanishes away from the jurisdiction of the registrar of companies.
Mr. Minister,